Welcome to Just Liberty, where justice and liberty meet. I'm Bettina Krause, editor of Liberty Magazine, here with my co-host, Alan Reinach, Executive Director of the Church State Council. Together, we're trying to recover religious liberty from the political extremes. It makes us sound like superheroes, Alan.
I don't know. The topic we're about to discuss makes me feel old because, it's the 23rd anniversary of a bill that you and I both helped to get enacted in Congress back in 2000, called the Religious Land Use and Institutionalized Persons Act. We used to call it of 2000 was the official name. So it's 23 years old, and it deals with religious freedom in land use, zoning, for example, and use issues, and also for people in jail, in prisons, incarcerated.
So I always think about it as the most important religious freedom statute that you've never heard of. Because really, Alan, this piece of legislation does a lot of heavy lifting, right?
It does. If you are involved with a church and you want to minister to the community, you want to maybe do a community garden or a homeless shelter or a radio station or so many things, and they tell you, oh no, you can't do that round here. Well, maybe you can actually do that because your freedom to practice your faith was the subject of this bill.
So, Alan, you have had experience litigating under this legislation, right? So what sort of cases do you deal with?
Well, one of the most significant one was a county that was really hostile against religious uses and did not want one of our Seventh-day Adventist churches to operate a radio station on premises. And, it didn't matter that we were on a 10-acre lot out in the country away from everybody, affecting nobody. And, what passes for a public hearing at the Board of Supervisors are neighbors saying that this radio station that is not even operational is impacting their television reception. That's what passes for testimony, right?
Crazy. So the second part of that name is incarcerated persons, which is sort of, and it's so funny how they've sort of sandwiched two apparently unrelated areas together: land zoning, land use, and incarcerated persons. So what is that?
Well, but let me give you a little bit of the history of that, or for our listeners anyway, because I know you know it, but, Congress was responding to a Supreme Court decision that struck down a prior bill called the Religious Freedom Restoration Act. And so the court said, no, that's too broad in trying to impose a constitutional standard by means of a statute. But if you're specifically remedying a problem, well, you can do that with a statute. So, for example, we have civil rights laws dealing with employment discrimination. That's okay. And so Congress had hearings, and I submitted written testimony about a number of situations, as did many, many others. And what Congress discovered was the real problems are falling into two categories. And so one category was discrimination against religious land uses, in no small measure because religious properties are tax exempt, and so municipalities favor any kind of use that will produce tax revenue. Also because, those applying for use permits are often newer minority faiths. They're not established in the community, and so they don't enjoy political welcome mat, as it were. And then the second category are prisoners, inmates, that, of course, you give up, so many rights because you're in prison. That's basic. But you don't really give up your right to your faith and to worship God. And so the prison's obligated to accommodate that basic part of humanity as it can within the context of the prison setting.
And in fact, the government's responsibility is heightened because of the level of control that they have over an individual's every aspect of an individual's life in that setting, right? And what are some of the issues? What are some of the practical challenges that an institutionalized person, an incarcerated person would face?
Well, I mean, there's, every kind of issue imaginable. Can you wear a beard? Can you obtain certain types of religious literature? Can you obtain a diet? Many religions, including our own, practice restricted dietary. So are you entitled to a specific diet that complies with your religious sensibilities? Do you have access to congregational worship? How well does the institution provide? So we will definitely have future shows where we can talk, drill down more. But for today, we're acknowledging 23 years of this bill, as you say, the most important bill nobody's ever heard of.
Well, on that note, why don't we bring on today's guest? We're talking about a very important topic, which is First Amendment jurisprudence and where the court's going.
It's our guest today, and I'm very happy to welcome Professor Stephen Green, an old friend. Professor Green is the Fred H. Paulus Professor of Law and Director of the Center for Religion, Law, and Democracy at Willamette University in Oregon, where he also teaches constitutional law, First Amendment. And prior to coming to Willamette in 2001, for a decade, he served as legal director and special counsel for Americans United for Separation of Church and State. And Steve, I know you've got an article to be published in an upcoming issue of Liberty Magazine entitled Disrupted Symmetry, which I presume is something to do with the free exercise and establishment clauses of the First Amendment. But what is your concept of disrupted symmetry?
Well, thank you for having me. I'm a historian as well as a law professor, and I've studied the founding period quite a bit. And I'm not an originalist, but I do believe that when the founders were writing the First Amendment, they intentionally put into religion clauses, not just one. And they saw both these clauses, the free exercise clause and the establishment clause or no establishment clause, as being not only co-equal, but both necessary to ensure religious freedom writ large. That you can't have a religious freedom with just free exercise. You also need to make sure that the institutions of the state and the church are not co-joined, that one is not overly influencing the other. And so I think there was a real purpose for putting these two in. And quite clearly, James Madison saw them as balancing each other, not in conflict, but as a balance. And so historically, throughout most of our nation's history, the Supreme Court has respected that there is a balance between the two, or a symmetry between the two. Now, the court has often said that there is room for play in the joints between the two. They don't necessarily have to go flat against each other, which allows for permissive accommodations of religion. But still, there's a purpose for disestablishment or non-establishment and a purpose for free exercise. What the Supreme Court has seemed to be doing in the last decade and a half, so to speak, is they've been minimizing, shrinking the no establishment principle. Whereas they have, I think in a not very helpful way, been trying to expand on the free exercise side of this. And so the symmetry seems to be gone. And so that was the article I wrote for Liberty Magazine, is just trying to trace some of the cases, but also just trying to make the argument for why we're going to be on the losing end if this asymmetry continues.
So, Steve, what I found, one of the aspects I found compelling about your article is you cite this study from Pew Research showing that 3/4 of Americans support the idea of non-establishment or separation. And yet the reality is that idea of separation is a vastly contested notion. I mean, it's a nebulous concept. We have to put, some clothing on it. So give us a sense of the sort of spread of different interpretations around separation and what that means in practice in America.
Well, certainly, I think on one extreme, which is not a position I take, but on one extreme, you may have people who want to just basically kind of drive religion out of the public square. And they believe that for there to be separation of church and state, there not only needs to be a secular society, which I agree, we need to have a secular government, but that we don't want to have any kind of representations of religion or even any kind of coordination between the government and religion to advance the common weal. That would be on one extreme. The other extreme would be separation only for the purpose of keeping religion as free as possible from any type of regulation, regardless of how beneficial that regulation may be, and seeing that that is somehow infringing upon free exercise when you have even health safety regulations. I'll just give you an example. During the COVID pandemic, there were many states had social gathering restrictions that were placed upon a host of different types of entities, clubs, restaurants, whatever, movie theaters, and that applied to churches as well. And these were neutral laws or neutral regulations. But many churches felt that it was infringing upon their religious practice unfairly to even adhere to some of these social gathering restrictions. And the Supreme Court ended up agreeing, basically saying that you couldn't treat religion any worse than any other entity, even though it was basically being treated the same as almost all other entities. So those would be the two extremes. I think most of us would see something in the middle between the two of them, because we don't want government to be directing religious entities or taking on any religiosity itself. And it needs to basically allow people to be religious if they want to, or not be religious if they don't want to, but consequently stay out of religion's way, but at the same time not trying to use religion as a tool, as some type of way of advancing public policy.
So this disrupted symmetry, if I'm hearing you, kind of increases protection for free exercise of religion, decreases the boundaries between church and state, and somehow has sowing within it the seeds of the erosion of religious freedom. So how do you see the either actualized danger or potential danger of this lack of symmetry?
Many people have poor impulse control. Let's put it this way. And those could be members of the clergy. It could be politicians. It could be a host of different individuals out there. And consequently, power is attractive and power corrupts. And I think that's a lesson that we have throughout human history. We shouldn't close our eyes to that. And so the concern is that when you start using religion as a tool for political power, or religious leaders start, nuzzling up to political leaders, then you are going to have the corruption of religion, but you're also going to have the corruption of government. You're going to have government starting to take on, again, religious positions because they think they advance the majority's wishes, the majority's will. And I think it'll end up actually imposing one person's religious beliefs on another person. And that's something we need to try to avoid. But unfortunately, I see where the court is going these days is it seems to be really emphasizing a kind of robust, but I think actually somewhat artificial notion of the free exercise of religion. And that I find problematic. Now, I can give you an example if you want. Well, I wrote a book several years ago, and I also went over this period in a more recent book about the kind of the history of religion in public schools. And in 1962, 1963, we had these famous cases dealing with prayer and Bible reading in the public schools. And the court rather definitively said that we don't want teachers or public school officials imposing religiosity on a captive audience of impressionable school children during the school day. And their role is not to be engaged in that type of activity. And that was pretty sacrosanct. I mean, there's been some complaints about it. And during the Reagan administration, there was an attempt to pass a school prayer amendment. And thankfully, that got co-opted in a sense. But what did we see this last term on the Supreme Court? We saw the Supreme Court siding with a high school football coach who claimed he had a free speech and a free exercise right while he's wearing his official garb to go onto the field at the 50-yard line immediately following the game and engage in a very demonstrative prayer in front of his players, in front of the opposing team, in front of the audience. The school had offered to accommodate him, to allow him to pray before or after the game, in the locker room, whatever. But he insisted that his religion required him to be on the 50-yard line and pray. I don't know of a religion that has those kind of requirements. Maybe there's one out there. But to say that that was a burden on his religion and a burden on his free speech, when he was still engaged in his official activities with impressionable players, I think that's just turning the law on its head.
Well, one of the elements of that case that I think bears watching carefully is, whether the court will recognize actual coercion. I mean, here, what those advocating for the school, the argument that they lost was the argument that the coaches' activities were coercive of the students, that, because of the imbalance of power and the coach's ability to give them recommendations for scholarships, coaching recommendations, playing time in the game, that the whole situation was inherently coercive. And it's my understanding that there was at least one amicus brief filed in the Supreme Court where students said, yeah, they were being coerced, essentially. So I think that whole, principle of coercion is something that is very much at risk with the way that the court is changing its view of religious freedom.
Yeah, there's a case from about 30 years ago, dealing with graduation prayer. And the majority, an opinion written by Justice Kennedy, he actually found that it was peer pressure, subtly coercive, when you actually had prayer at an official school graduation exercise. Justice Scalia, in his dissenting opinion, said no. He wanted to see kind of, I don't know what you want to say, almost like the Spanish Inquisition type of coercion before he would recognize there actually is some type of coercive activity. Now, was not paying attention or not recognizing the fact, though, that children do act in consort with their peers, with their classmates, don't want to be ostracized, want to be part of the group. And so when you start requiring that the coercion be almost, thumb screws or whatever, then I think that's just not the reality that we see within the public school context. That's what the Supreme Court seemed to be going toward, though, in this most recent case dealing with the football coach. There was no direct evidence of coercion, although you're right, Alan, there was some evidence in the record that you had some students who said, football players who said, I feel like I had to go along with this. And for some reason, the Supreme Court just disregarded that.
So let's talk about, beyond the issue of coercion, let's talk about the issue of state funding for religious enterprises. I mean, there was another case, right, Steve, recently that dealt with this, and that really has ushered in a sea change in the way these funding issues are dealt with in the federal courts.
Yes, I mean, this is the other one that helped kind of turn free access Establishment Clause jurisprudence on its head. Traditionally, the Establishment Clause has meant that the government should not be funding inherently religious activity. Again, it doesn't necessarily mean that it can't fund neutral social service programs of religious providers. It's been doing that since the middle of the 19th century. But it should not be funding any kind of religiosity that is going on. But the court has also recognized that most private religious schools integrate religion throughout their curriculum and often require the students to attend specific religious worshipful services and activities. And so the general rule has been we cannot have direct funding of religious or parochial schools, because that would then end up having the government funding the religious mission of those recipients. There's also just the general public policy that the government has an obligation to fund the public school system, the one that is directed, the one that is administered by the public. And so that more or less had been accepted for a long time. Well, in this case that came out of Maine, what happened is the state of Maine, being a very rural state, there's some quote-unquote school districts, some counties that actually do not have their own public high schools because of just a small population. And so the school district would give, you want to call it a voucher, or give, actually they wouldn't even give a voucher so much. They just paid directly for the students to attend private but non-religious schools. And so these became surrogate public schools in a sense. I lived in Vermont for many years, and Vermont has the same type of system. And actually, in the next township over from where I lived, there was not a public school. It was a private academy. And so the kids went to that private academy as the public school. And what ended up happening is some parents wanted to put their kids into a private religious school. The state said, no, our obligation is only to fund private or public secular education. They said this discriminates against religion. We went to the Supreme Court, and the Supreme Court again agreed with the parents. And so they basically reversed. In that case, it wasn't 50 or 60 years of Establishment Clause jurisprudence. It was really going back of 150 years of Establishment Clause jurisprudence to say, not only could the state fund religious education, but to refuse to do that would then discriminate against religion. And so we still don't know where this is going to go at this point, because we're going to see a lot of cases where you do have within public schools, and I teach education law at Willamette, that most public schools often have contracts with private entities to do a host of different types of services for students that the schools themselves are not either qualified or they just don't have the manpower to do. And so what that means, we're going to have to see whether this is going to start involving that you have to also then do contracts with religious providers for some of these services. What is this going to do with charter schools? And that's the next one on the horizon. Is it if you have charter schools, which are technically state-run schools, even though they have a private board of directors, and so they're somewhat independent, is the state now going to be required to fund religious charter schools? And so there's a case out of Oklahoma is already started. It's going to raise that question.
Well, listening to you, Steve, back to your theme of a disrupted symmetry, I'm struck by how it is that now religious schools can be, amply funded by the state, and yet the state is now precluded by Supreme Court doctrine from enforcing basic civil rights laws on the faculty with respect to protecting the rights of the faculty of those schools. So even though, and you well know the cases I'm talking about, you have elementary school teachers in Catholic schools who bring disability discrimination cases, and they have little or no religious obligations. At least one of them is not even professed to be a Catholic, and yet the court regards them as ministers, and I put that in quotes, who the employer can fire at will and does not have to comply with non-discrimination laws. So, here, it used to be there was kind of this symmetry where, okay, the state leaves you alone, and you leave it alone. You're not funded by the state, you're independent. So there's kind of a balance there. But now the balance is in terms of religious education is way out of whack. Wouldn't you agree?
Well, I agree completely because I think that's where we're already going there. You're right. These are some cases in the last few years where the teachers were dismissed not for their lack of faith or their inconsistency with the religious mission of the institution. They were dismissed because of disabilities. And we have these important, Americans with Disabilities Act laws, state laws, that prohibit an employer of a certain number of employees from discriminating on the basis of someone's disability. It has nothing to do with religion. But to exempt religious providers, religious schools from complying with that, and then turning around and then funding those religious schools, what happens to accountability? Accountability internally within the school, but then accountability more largely when it comes to accountability to the public when you have those type of scenarios going on. And I respect those religious entities, like religious institutions, schools. The Seventh-day Adventist schools that don't take public funding, or Brigham Young University, which does not take public funding. Right? Then they have the option, if they want to not follow these civil rights laws. I always hope they do. But you can't have your cake and eat it too, at least traditionally. But now we're going to have public funding of private religious entities, private religious schools, and there's going to be next to no accountability of that funding.
So, Steve, we're getting to the end of our time. But before you go, I want to ask a question on behalf of those who may be listening and who may be people of faith and who may be saying, wait a second, how can anything that assists religion be problematic, be a bad thing? People who may not have engaged with these issues to the extent that you have, and who are simply saying, as much of the religious media coverage of those cases that we've been talking about, as they did, they portrayed these cases as an unmitigated win for religious freedom. What is your, elevator pitch for why separation of church and state is a good thing, not just for all Americans, but specifically for people of faith?
Well, my elevator pitch is I think we just need to look at American society and see, even though there's new polling coming out about the declining number of people who go to church regularly or who believe in God, still compared to all other westernized, industrialized countries, we have the highest rate of church attendance, the highest rate of people professing faith of some type. We have robust religious communities, providing social services and providing spiritual comfort, etc. Right? That has all existed under this regime of separation of church and state, under this regime that has had this equipoise, that has basically had a symmetry the way it goes about addressing religious institutions and religious issues. My fear is that if we start losing that symmetry, that you're going to have the government start engaging in some type of potentially preferential treatment of religion. That's happened historically. When you remove these guardrails, you might have the government start, again, expropriating religion for its own purposes. Religion works best, I think, when it works independently, and that we allow religion to exist independently. But once you start funding religion, a dependency is going to occur. And the government might start calling and might start saying, hey, we're giving you some money. Can you support these particular policies? And this exists in Europe and other nations. So we should not act like we're immune from these tendencies.
We're going to have to continue this conversation because there's a lot more to talk about.
That was quite a conversation, Alan. We covered a range of topics there.
It sure was. And it leaves me reminded of the old adage about the other golden rule, that he who has the gold makes the rules, and that, the churches depending upon government funding is a very, very bad idea. Well, this has been Just Liberty, where justice and liberty meet. I'm here with my host, Bettina Krause. I'm Alan Reinach. Until next time, remember, eternal vigilance is the price of liberty.